Good morning, everybody. So we have Gennady Litvin from the law office here at Moshes talking about a very important topic today. And this is actually probably part one to his office presenting some information to us, and that's going to be fair housing. This is such a deep topic. It's an important topic to myself and our organization and our commitment to educating the consumer and being a public servant. So Gennady, I'm going to give it right to you since this is such a heavy topic. I ask that for those that ask questions, please go ahead and put them in the chat box, and we'll be happy to get to them as we get closer towards the end of the meeting. So thank you, Gennady, for doing this. The floor is yours.
Absolutely. Thank you, everybody, for dialing in on this beautiful Friday morning. I'm going to start with the end in mind here. I'm not going to start with the beginning. As you can see, hopefully, I'm sharing on my screen one of the newest and most recent developments. Hi, Gail. Is that Governor Cuomo has now signed into legislation allowing the Department of State to pull our licenses, revoke our licenses if we are found to be in violation of the fair housing rules. And this literally just came out, I believe it was at the beginning of this week. So this was a great time for us to be joining this meeting and kind of this conversation to talk about what is fair housing, what are we looking out for, and essentially the do nots, the don'ts of our regular practice and what we're doing on a regular basis. So just in a nutshell, I'm not going to go into any of the legalese for you guys. Here's basically what the governor signed in. This is the code. Basically what this is the fair housing code. This is the code that as it relates to the powers the Department of State has over real estate agents. And you see here in green, they've added language where it now says, or for violation of Article 15, which is fair housing, they now have the right to revoke the license of a broker or a salesman. Now, that is a very thin connection in between kind of the real estate agent and the possible tenant or the landlord where fair housing comes in. Let me just go off by saying it's not only real estate agents, it's not only brokers, it's not only landlords that are bound by these regulations. And in essence, we've got federal and state rules and laws that guide us on the fact of fair housing. So what we cannot discriminate on. So let me just pull up the categories here that I have. And this is basically from the Attorney General's office here, from their website directly. So federal rules make it illegal for us to discriminate on the basis of race, family status, color, national origin, depending on where they're from, religion, disability, or sex. Now we have the New York State human rights laws. They also protect certain characteristics that the Federal Housing Act doesn't touch on. Here we have sexual orientation, creed, age, military or marital status. So whether single or married. And then we have even further protection that New York City provides us with. It's going to be gender, citizenship status. So depending on what type of citizenship status you're in, landlord, us as agents, we can't make a determination on the application based on their citizenship status. And based on financial status. And that's a biggie but goodie for all of us. What does that mean? We can't go ahead and treat anyone with vouchers differently when it comes to showing units or when it comes to trying to rent or sell these units. This all comes out of an investigation. I think most of you will remember. Last year, there was a few brokerages in Long Island that then hit the papers where there was systematic discrimination that the Department of State found. And this is where the change in law comes in from. Things to mention that in terms of who is bound by by these rules. So it's not only uh, landlords and agents. We also are covering staff of management companies. We also are covering staff of real estate companies. So whether you're licensed or not, let's say you have administrative teams, they're part of you. So don't think that just because you're not making the call or the final decision that you're going to be off the hook. Next, we also have, if there are rental agencies that are doing consulting work, they're also going to be governed by fair housing and all of the requirements. And the bottom line is, when you are faced with a landlord or property owner that is giving us strict and direct rules and guidelines in terms of who they want as tenants and who they want as next owners, you are the tip of the sword when it comes to educating them and notifying them as to what can be and cannot be done. You cannot go off and use the defense that, well, I didn't do anything or I didn't say anything because of the fact that it was the landlord, it wasn't me. That's not going to be an excuse. It's not going to be an excuse that the landlord only wants a particular religion. It's not going to be a particular excuse that the landlord doesn't want to deal with anything for disabilities as well. Disabilities is a big thing. If a landlord needs to put a ramp to access the building, that's something that needs to be done. Because then the ADA comes in and they can provide them with the violation, and not only you if you are discriminating against those with disabilities. Um, Family status, right? So if we have a family of, let's say, 2 children, and a landlord doesn't want children in the unit they're looking to rent out with you, that's not something that you can put out or marketing listing or even use as a barometer for the applications that you are going to be accepting. That is discrimination on familial status, and that's a biggie. Um, let's go back to what probably all of us are dealing with on a regular basis: vouchers, subsidized tenants. Can our landlords deny vouchers? And, I'm going to say, in combination with federal and state and New York City, I'm going to say no. Unless you're a single family or 2-family property, you cannot be denying vouchers. And these are very important elements for all of us to keep in mind, because whether we're real estate rental agents or whether we are sales agents, at the end of the day, the rules apply the same way. If you are listing a property and the seller tells you not to accept viewings from a particular race, from a particular gender, from something that's limiting, you've got to educate them and notify them right away that that's not something that you can do
Gennady, I
based
just
on
want to go
fair
back for
housing.
a second because it's important. I'm sorry to interrupt, but I just want to go back to make sure we have a clarification. So you mentioned something about 1, 2 families with vouchers because, especially during these times of these tough times in New York City right now, we know that some agents are receiving calls about those folks that are looking for um, housing. And one of the things that came up, not come up, there's quite a few, and we actually were having a special guest in a couple of weeks talk about vouchers and what it means and how much they can get and what the landlord can get to educate our agents. Can you just touch on, when you mentioned 1, 2 family occupants, can you just touch on that just one more time?
Yeah, sure. If there is an owner occupied 1 or 2 family, as you can see on my screen right now, this is coming directly from the Attorney General's website. As far as New York State and fair housing, What is not included and what the exception will apply to, meaning one or two family properties that are occupied by owners are not required for the acceptance of a voucher. Um, those rules do not apply. But again, we need to make sure that we are looking at what I am trying to point out. They need to be owner occupied buildings. These aren't investment buildings that we're talking about that somebody has in their portfolio. These need to be owner occupied buildings. So if we are being frank, a one family property that is occupied by an owner, I think that pushes them outside the bounds of being able to rent anything inside of their building legally anyways. Um, a two family owner occupied has at least another single unit to rent out. So that's in a situation because it's so intimate and because the owner lives there, that's not something that the law will mandate. Um, that's really the most important exception that we are being confronted with on a regular basis in the boroughs. I mean, otherwise, what we're dealing with are the other exception. We have generally halfway houses where it's for women or battered victims that have been battered, or we have exceptions that pertain to communities, generally 55 and over, 65 and over. That also is an exception in terms of age discrimination or the limitations that are allowed by the state. Other than that, you can imagine that everything is much illegal to really refuse based on a particular protected class. And here's some typical examples that the Attorney General writes about, and the Attorney General is one of the sources that you would file, that a complaint would go to against a brokerage or an agent in addition to the Department of State.
And Yuri, Gennady, just give me one more sec to make sure that they hear from me on really best practice from my experience here, not as an attorney. You know, when communicating with the consumer and they say, and the consumer says they have a voucher and they're looking for assistance, does this particular person accept vouchers? Guys, the best practice is to say, yes, I'm here to help you. And yes, landlords are to be educated about vouchers, and you know, all landlords should be open to taking and working with vouchers. Remember, the easiest way to just say, yes, I'm here to help, I'm here to educate, and yes, there are minor exceptions to this, but far majority of owners have to take vouchers. A far majority of owners have to take vouchers. Reason being is because if you're going to say something that is out of line, I mean, it's pretty much, there's only, what, 3 exceptions over here. And I just think that it's, in terms of most of us and how we communicate with consumers, I mean, in most of the housing stock that we work with are not halfway houses and things of that sort, as Gennady just described. So, but if there is a 2-family owner-occupied place, but let's say it's not a specific building that you're particularly working on, best practice is to say, yes, we're here to help, we're here to educate, and truth be told, you are, guys, you are public servants, you're licensed by the Department of State, so best practice is don't go out there and look at these exceptions, go out and help. And that's really just what and Gennady, I'm sorry to interrupt, I just want to make sure that agents understand that you're not here to look for the exception, you're here to help. If there's an owner that this applies to, then yeah, then that particular owner, again, according to Gennady and this over here, yes, they might be the exception. But as agents, best practice is to say, hey, help. If you're doing rentals, you're doing rentals. You help everybody. You give everybody equal treatment. Go ahead.
Thanks, Mike. And I'm still going to leave it highlighted here where I put in owner occupied. I think that is going to be, that continues to be the biggest element of this exception that a lot of landlords try to play games with. So don't get into that world of trying to decipher what this means. As far as you know, and like Mike said, I think the best practices are just go along with it and help, and then you deal and educate with the landlord themselves in terms of whether there is an exception for them or not. But I would always side on with caution when coming to or letting a tenant know that there isn't some sort of exception to the particular unit that they're looking at. I would say just go for it, like Mike said, with trying to help them, and then speak to the landlord directly. Um, the most typical types of discrimination and legal actions that generally are seen are literally written right here. What I see a lot these days has to do with social media. And I don't think a lot of agents recognize that whatever it is that they're posting, even if it's for a friend and if they're licensed, they're still on the hook on based on these types of guidelines. So I think to kind of summarize, what I'm seeing as the biggest element right now is social media because of the restrictions due to COVID. I think a lot of the investigators are using social media to make these calls and to make these secret shopping experiences brutal for all of us. But just make sure that we are not speaking to anyone or posting anything in any public platform, anything having to do with particular types of tenants or buyers that we are focusing in on. Do not push any type of particular loan on a property as well, because that may also be looked at potentially as a situation. And what do I mean by that? I've seen some situations where a listing would push FHA loans versus conventional. These things are that fine line in terms of what are you trying to put out into the public to facilitate more leads coming into you. And the Department of State looks at it as, well, why are you putting FHA loans in the listing agreement if this is something that can also be accessible to any type of conventional? And then they start looking at whether is this community specific or if this is specific to the listing agent. So don't get into that type of world as well. Landlords are known for threatening behavior. So if you are dealing with situations where a listing that you have on behalf of a landlord is trying to force, and by force I mean I'm trying to use my verbiage very carefully here. So give me a minute every now and then if I'm thinking to myself to try to put it correctly. Let me give you an example of a situation, I guess, that I am thinking of, and it'll be the easiest way to explain. If you have a landlord that you're working with that is looking for a tenant for their unit, and the landlord is telling you that, well, we're in a particular neighborhood right now, and I don't think our neighbors are going to want any type of different creed, let's say. Please try to focus on this particular type of community to bring in here. And then the landlord says, well, if you do this, I'll give you, 2 months. Or if you don't do this, maybe I won't do anything for you. This is very important because at the end of the day, although it's not in the public, it is out to you. That information is out to you as that public servant. And if you don't do anything with that information, if you do something with that information that will facilitate the landlord's request of you, you're in the same violation as the landlord. And what happens there, you're included in the caption from the Department of State and from any private lawsuits alongside that landlord. So that's very important. Just because it's not being said by you to in the public, if the landlord says something like that to you, use that opportunity to educate right then and there, so to establish that form of abidance with the current rules and regulations.
Gennady, if your presentation allows later on, or you want to talk about it now, co-op boards have very specific financial guidelines in many cases that they share to the public, not to a particular agent necessarily. Say, hey, they have to fill out these applications. Same here. Would you say that a co-op board had conversation with an agent, are we under the same guys over here? And actually, I'm being a little silly. Um, I know we're under the same guys. Can you help us out a little bit, because I hear things in the marketplace. Um, can you share a little about what your experience might be
Yeah.
with co-op boards?
Co-op boards are type of local, I get in Russia we called it krysha. It was a roof, mafia. But basically, what tends to happen with co-op boards, they have their own kind of intimate rules. They may not be listed in the purchase applications, and you may hear a conversation of a board president or member that's giving you a heads up. Hey, we're not looking for somebody that's coming in here with a let's say payroll coming in from a nanny position, or we don't want somebody that's coming in here with a fixed income, or we don't want someone coming in here that's, let's say, in a wheelchair. um, and this type of information that you will receive even off the record, you've got to take that opportunity to take it back at them at this point, because again, you cannot be the tip of the sword for that board looking for somebody that they are telling you that they want, meanwhile segregating against everybody else that is essentially discriminatory in nature. We see it all the time, we hear it all the time. The problem that we always have is, how do we prove it, right? One thing that is becoming a lot easier right now is disability. So a lot of times we are seeing that, and disability having to do with pets. Do you have some sort of pet that you are planning to take in with you that the condo or co-op board doesn't allow inside of the building? Well, if the tenant or resident of that unit can show that there is a disability and can provide that this animal is for that disability, then the co-op or the management board at that point, they can't deny that applicant because of the fact that they're bringing in this pet, because now it is an accommodation for a disability, and that's a requirement of the law. We hear that a lot. Another thing that that we see, and one thing that I've told agents to ask board members of, is when there is a denial, and there's you have no idea why the denial came in because you see good income, um, ask the board a question. Ask somebody a question there if you can, because they talk. They're people and they talk, and they may help you or they may hurt themselves. But at the end of the day, you are going to be that individual that is going to provide your client with more information. And at the end of the day, hopefully in the future, you'll be able to fix the situation that hurt your client there. So ask the question in terms of the board and co-op or condo as to why the denial came in. I generally do not like to take a denial at face value. I will always ask and get more information, even though generally they say we don't have to tell you anything. Unavailable housing. So we see that as well. Sometimes we see properties that are going in and out of the market. Landlords think that they're tricky, and they will use that element as to saying, well, the unit's no longer available to this particular applicant or to any string of applicants moving forward. A month later, you'll see that the unit's back on the market. Don't be inclined to use that as a way to get around your landlord's requirements, because your landlord may push. Just because they take it off the market and you tell that to the applicant, and then later the applicant somehow finds out a month later the unit's back on the property, they're calling somebody like me, they're calling somebody like my office, asking or making accusations and allegations into, hey, I have a family of four. This landlord was single. I didn't think that they wanted a family, but this proves that they really didn't, because they denied my application, said the unit's unavailable, and a month later I see it's back on. I want something. I think that they violated the laws here. We don't want that call. That's not a call you want to deal with, because then they're also calling the Department of State, and then you're being secret shopped. So again, be that reasonable mind for your clients, and your clients being the landlords. Most importantly, that you need to train properly as to what's allowed, what's not allowed. Um, don't set different rates for different people. That's going to be a problem. So if you start setting your rental rate with your landlord for $3,000, and then somebody calls in and you set their rental rate at $3,500, that's a question. That's questionable. And again, you don't want to be put in the situation where you're going to be answering as to why you raised the rent for this applicant for $500. Meanwhile, everywhere else you're marketing for another price. That's a biggie. I don't see this much, but sexual harassment. If you have a situation where you have a client that you're having a relationship with, um, don't do it. Don't represent them on a client, or don't have a relationship with them, whether it's a landlord or a tenant. That's just a big no-no, because at the end of the day, it goes back to coercion. It can always go back to coercion. And as we know, these are big things that we just don't want to answer questions on. And, again, I think that advertising is the biggest issue. Keep your advertisements extremely clean. Do not point to any particular class. Do not point to any particular category of people. Sometimes what I see whether it's an SRO or whether it's a multifamily, somebody saying, well, woman looking for other women to join in a property, or something to that effect. That's just bad news bears. Don't do that. Don't represent somebody that's looking to do the same thing. Mike, you jumped in to say something?
No, I was just showing my face.
Looking good. All right. Disabilities. Disabilities is a big thing. And one of the things that I'm going to continue to mention is the fact that our landlords, our clients, can't make different decisions based on the fact that it'll cost them a few more dollars to accommodate a disability. For instance, if there needs to be a ramp to enter the building, that's something that they're going to have to do. If the mailboxes are too high for somebody to reach that's sitting in a wheelchair, they're going to have to accommodate, perhaps put a lower mailbox to somebody like that. But they can't discriminate, because these are reasonable fixes that the law sees that it's something that can be done. At the end of the day, right now, we're all at risk of having our license revoked or suspended because of the Attorney General's new passing of the regulation. If you have any doubt in terms of what you're being asked to do, how you're being asked to market a particular unit, I think it's always advised to urge on the side of caution, whether it's speak to your team members or your broker or the attorney. Get advice, ask the question. It's a lot easier to be preemptive and proactive than it is to be reactive in the world that we're in. Even though they have these fines capped at $1,000 as to violation, the $1,000 violation does nothing if we are suspended from our license for 6 months, 3 months, or 12 months. That means that we can't get our money, we can't get our commission, even if things are in the pipeline. That could be an issue. So don't get your bread and butter taken away. Be very conscious of what it is that we're marketing and how we're marketing it. The people
So,
in Long
question, Gennady, about
yeah.
the license revocation. So, although you're saying it's 1,000. Say that again. So it's
It's right
$1,000
here.
for.
So what they mentioned here is that the violation is $1,000 if they find to be not to exceed $1,000. But because of the new law that was written in by Governor Cuomo, that $1,000 really is of no relevance to us, because the most important thing that we're now concerned about is losing our license. And here it goes. Department of State may revoke the license of a real estate broker or salesman, or suspend the same for such period as its a department or in lieu thereof may impose a fine not exceeding $1,000, okay, for a violation of Article 15, which is the fair housing rules. So it can be one or the other, could be a combination. It says here or in lieu thereof. It's not what we want to deal with, because when you are being addressed by the Department of State, you're getting representation. It's no way costing you $1,000. Always protect yourself and ask the proper question of yourself. Is this going to pass the red face test? And the red face test in my world means that if you are standing in front of an administrative judge or on a panel and you're asked as to this line that you wrote, or this text message that was sent, or this statement that was recorded, who was it directed to, and what was your intention behind it? If you can't give a straight answer without turning red as to the legality of it and it's correct, that fails the red face test, and you shouldn't be doing it from the get-go. Get on the phone with one of us, ask the question, let's see if we can guide you in the right direction. And at the end of the day, all it comes down to is just educating the landlord properly as to what they can and cannot do. So let me just open it up to questions in case anyone has any. That's really the gist of the fair housing rules of the don'ts.
Yeah, so while they're getting the questions, Gennady, I'll ask a question. So if a homeowner violates these, any of these notices here, are we told to educate and then not work with that client anymore? Is from what I was, another attorney at some point had said to us, is that we're advised that especially if it's a, not especially, if there's a landlord or who's looking to rent their apartment, or there's a homeowner looking to list their house, we educate, but then also, are we told not to work with that customer anymore? Is it something that's best practice?
Okay. So in terms of best practice, okay, best practice is always going to be not to put yourself in a situation where anything that's already out on the market can conflict with what your intentions are.
Okay.
And what do I mean by that? So let's set some distinctions apart. I'm going to set a distinction between that 1 or 2 family homeowner versus that landlord that's got that 6 family and up. Okay. The 1 to 2 family homeowner generally are not out there mass renting units, especially if they're residents, if they occupy the building. So for the most part, if I'm going out, or if you're going out on Google to look at their previous listings, to see if potentially there has been any violation, you're not really in danger of finding too much information out there, especially if they're an owner occupied type of single family or 2 family unit. So I'm not as concerned about that area and those types of properties. I'm more concerned about those institutional landlords. Let's go into the 3, 4, 5 and up unit realm, because they are the ones that generally will go on these different websites and post their units out there themselves and write things into the listings that are contradictory to what the law says. And then if you're going to potentially take that client over, you have to worry about what has been written about these listings in the past. So if you do that, I need to make sure that you understand. Don't put a listing live. Don't put anything live until you clean up what's already out there on the internet in the past. I'm not as concerned about them being sued in the past. I'm more concerned about the fact that they don't have anything else remaining online, whether it's social media or anywhere else, where they may be misrepresenting as far as what their power is in seeking out the tenant that they want. That is my way as far as best practices. 1 to 2 family, do your due diligence online. Less inclined to be in danger there because they're less inclined to be renting things out on a regular basis. The other landlords, the ones that are more inclined to be doing this on a regular basis, I would take a lot more time looking into their background in terms of listing history to determine that you're not going to be tied to something that they've put out there in the past.
Got it. And then, when they're trying to sell a house, condo, co-op, whatever it may be, this fair housing notice, when they're doing an open house, needs to be displayed prominently. Any advice or tips on that? Uh, because they're also, you got the agent must also fill out the fair housing disclosure form immediately when engaging with a customer. Any best practice or any tips on that?
Have it there with you when you're doing open houses. Make sure that you just have it there during your open houses. Potentially don't get inclined to get into a serious conversation with anyone without this disclosure. As far as the for sale by owners that are doing their own open houses prior to you getting in, I'm less worried about that because you don't have control over, or you would have no way to obtain that knowledge or information, reasonably speaking, um, as to whether they put that notice up. The only thing that you can do is you can make sure that you're doing it on your end moving forward. So I'm not as worried about whether that disclosure is there during a for sale by owner open house. I'm a lot more concerned about making sure that it's there extremely in a prominent location and for everyone to be aware of moving forward so that the past doesn't mix in with what you're doing.
Words like, is this a safe neighborhood? Um, are the schools good? What type of people live here? Just can you give me any comments on those things? Because
Yeah.
agents, yeah, can you give me anything on those? Especially, let's start with the first one. Is this a safe neighborhood?
We're salespeople, and by we, I'm also throwing myself in there into this mixing pot. When we're talking about and when we're asked that type of question, your response needs to be as general as it can be. You can't, you should not point into a particular statistic unless you want to be caught by it, because statistics, as we all know, are are extremely available and they can show one side or the other side depending on who the source is. And the Department of State has their own sources, and what you are relaying to this prospect may be relying on a completely different source. Don't get caught with providing some sort of statistical information that may have potential to be argued against. And if you're using that, again, it's something that you're putting in print form. So it goes back to what we're talking about in marketing and advertising. So if you're asked, is this a safe neighborhood? I'm not going to go into the preferred way, Mike, that you would want them to respond because I don't want to step on your toes there. I just want to make sure from the legal world and the legal realm, you do not start pointing out either specific issues or in issues that you have found about the particular neighborhood. Just generalize it so that you don't get stuck with something that you put out that can be used against you later.
I think that as agents, and this is something that has came up for me during this whole uh, thing, we have to know what our job really is. And our job is not to interpret what if this particular neighborhood is safe. Our job is to sell the house. And you know, I thought that was an excellent point. If we're pointing to statistics, right? Because a lot of times people say, "Are there good schools over here?" It's the same thing, right? You're pointing out a statistic that, as you put it, there's two ways to look at it, right? I mean, I know when Googling stuff, I mean, there's biases when people are putting out their, statistics, as you said, pointing statistics. So stay away from that, and then you'll be okay. I think it's a pretty simple answer. I think focus on the amenities of the house, the size of the house, the price, does it have a backyard, and you're going to be okay. Because at the end of the day, Google allows people to do their own due diligence, and it's not the agent's job to interpret that, right? Do you agree with that, or right? I mean, it's the agent's job.
You and I have a lot of these conversations, and we always say, end up with a lot of times less is more. And when we're
Right.
talking about here, this is one of those particular situations. And whatever you decide, whether it's during the listing presentation or whether it's going to be during a buyer presentation or a broker open house or a regular open house, be careful what you're putting out there. Be careful what your marketing material is in terms of what you're putting out there about the neighborhood in general. I'm
And
always
educate
concerned.
yourself. We have literature that we give out to every single agent. It's made readily available. Literally, it's in your face, showing you what NYSAR gave us some guidance. There's so many publications that we make available to our agents to educate themselves. That's why we're recording this and we're going to distribute it, because it's a really important. Agents are independent contractors. It's important to stay educated and stay in front of this, because your business is online as well.
Independent contractors, actually, great point. Boards, co-ops, landlords, right? A source of income, really, as long as it's a valid source of income, cannot be discriminated against. We have a lot of landlords, we have a lot of boards and co-ops that don't like independent contractors and don't like 1099 income. I'm literally dealing right now with a condo board that doesn't understand how an independent contractor gets paid from an entity that they are a member of, and they want a CPA letter. And I'm like, there's no CPA. Are you going to pay for the CPA letter? So there's so many things that are actually happening in conversation right now with this condo management that they don't understand, that they're really teetering in that fine line of, are you trying to verify the fact that there's income, or are you trying to deny based on the fact that you don't like the income? And that's a fine line that we need to be aware of. So don't look down upon independent contractors. They're complete ways that are viable. If the IRS can take that verification income, sure as hell you can bet that a managing agent should be able to as well. So I just wanted to make sure that I point that out, because I'm seeing that, as unemployment goes up, people are starting to start their own businesses and so be more self-sufficient with income. It's going to come up more so moving forward. Any other questions?
Doesn't look like I see anything in the chat box as of yet. We're going to continue, guys, into this and the rest of this month and next month, focusing on education and awareness around even programs available. We have some special guests coming up in the month of September. We'll be educating us about the programs available, because as a company, we want to make sure that we are staying in the front lines and of all of this, and educating ourselves on what's available to help the consumers out there, educate, to basically assist in this fair housing notice and follow with the 17 protected classes. So thank you for your time.
Absolutely. I just wanted to bring up one thing that I also see that I wanted to mention is that one thing that I mentioned, on your listings, if you have that your listing is looking for the 3.5% down FHA loan, it's also the other way, that your landlord will not, or that your owner will not accept any FHA loans. That's also a problem. So it's the reverse discrimination of it. So again,
yeah, that's interesting that you brought that up, because that's FHA, VA. I've heard that in the marketplace. And people have said that different things about why in terms of the program wouldn't work for them, but that is a violation of fair housing.
That's correct. So you got to be aware of it, especially if you're a buyer agent and you're trying to be competitive and you see something like this on a listing. Make sure you address it with that listing agent and make sure that you bring this to their attention. Yep. And let them know that you got a qualified buyer ready to go.
Got a qualified buyer. Now, Gennady, you just, we talked about co-ops earlier today, who do have minimum requirements, 10%, 20% down payment. So from my experience with the FHA, the customer could put down 3.5%, but there are some customers that could put down 10%. I would imagine then that would be a discriminatory act if the customer could put down 10% FHA, right? FHA is loud, they could put 10%.
Yeah. But here's the thing. Because this is all pre-negotiated as far as contracts is concerned, the seller still has the right to say, I don't care how much in mortgage you get. I want to make sure that you have enough skin in the game to make it worth my while to
I
tie my
lost your
property up.
audio. Hold on, go back. I lost you for like the what? Say that again. Yeah, the seller has the right to say.
Oh, that I'm sorry if you lost me. The seller still has the right to negotiate their contract. And when negotiating their contract, just like a co-op board or just like a managing agent for one of these boards can say, look, we need to make sure that you have enough skin in the game if we're going to take this unit off the market for 90 days. And the only way that we can make sure that you have something on the line is if we request that you put X amount of dollars down. You can go get your loan for whatever amount, get over the amount for all we care, as long as we don't have to pay for it or the expense isn't ours. That's why you've got sales concessions out there too, right? So this is a negotiating element, and it's a very sensitive area. If you have any questions in regards to how to approach it when this is confronted with you, feel free. We're available for you at any time.
So as we wrap over here, I pretty much I know that everyone knows you on this webinar, but can you just tell us where to find you and your office if they have questions about this or any real estate related legal matter? Where can they find you, Gennady?
Thanks, Mike.
Where they can find you and your office?
Okay, so we're always online, mosheslaw.com. You'll see all of us there, all of our contact information there. Email address is extremely simple. I'll give you a blanket email address that bounces to several of us right away, so it's never missed. info@mosheslaw.com. Our office right now is on Brighton Beach Avenue. That's our main office that is, for the most part, empty now because a lot of us are working remote and virtual. We have a second location that we work out of in Midtown Manhattan, and we are extremely busy right now in the Harlem area of Manhattan, so don't shy away. Sponsors are loving to give concessions right now to all of those units that are standing and not getting enough action. So we're getting to see good things there. Most importantly, I want everyone to know that we're always available. I think that everyone in the office that knows us has our cell phone. So if you don't have our mobiles, my particular one is with your colleagues, Igor's, Yuri's, everyone. We just brought on 2 other attorneys into the team. So we're not a one-man shop. We're growing, and we're going to continue handling things for you guys, whatever comes across.
Great. Gennady, thank you so much. Thank you everybody for your time. Have a great day. Bye everyone.
Thanks, Mike. Take care.